Okay, again, our second case on the February 26, 2026 docket is case numbers are consolidated 2024-1148 and 2024-2588. Star Casualty Insurance Company versus Jacksonville Chiropractic as assignee on behalf of Marie St. Hilaire. Apologize if I mispronounced that as well. Correct me if I mispronounce it if it comes up. All right, counsel, if you're ready for Star. Again, you have 5 minutes. The yellow light will come on if you start going into your rebuttal, or tell us how much rebuttal time you want first so the marshal can adjust the clock accordingly.
Okay. Ashley Paxton on behalf of Star Casualty.
What was your name again?
Ashley Paxton.
Ashley Paxton, okay, thank you.
And I represent Star Casualty.
All right, and you'd like 5 minutes?
Please, 5
Okay.
minutes.
All right, counsel, go ahead.
Okay. In this case, we have a policy that excluded coverage for injuries that were sustained while in a vehicle that was not owned by the insured or the spouse. The insured was in an accident while in a vehicle that...
Well, just make sure, it was owned by the husband.
It was owned by the husband.
But it was not titled in the wife's name, but she lived with the husband. They were a
lived
married
together.
couple living in the same household where the premiums and the policy, premium notice and the policy were sent.
Correct.
Okay, go ahead.
Okay, so she sustained injuries while in the vehicle. She went to see
For the record, this is the 2007 Ford Taurus vehicle.
the 2007 Ford Taurus.
That you're saying at the time of the accident was not insured under the
It was not,
policy. So therefore,
correct.
there was, PIP coverage was denied, and the trial judge erred in finding that there was PIP coverage.
Correct. The trial judge...
Because your side not only lost, the other side won, and that's why we're here on appeal.
Correct.
Because there's a final judgment that gives us jurisdiction, right?
Correct.
Okay.
Okay, so in the trial court denied summary judgment for Star based on finding that that Star needed to prove that the insured intentionally removed the Taurus from the policy, and
But
also...
even though that's not in the statute, from I understand your brief, I mean, if Star just, and I'm saying this metaphorically, if Star just woke up one day and said, we're canceling all Ford Taurus policies on everybody's policy, and didn't let the insured know, that would be a problem, wouldn't it? If the following day, then one of the insureds or the spouse of the owner was in an accident and thought they had coverage.
I think it would be a notice issue at that point.
You think?
It could be.
Why wouldn't it? I mean, I don't want to get off in an academic tangent, but I mean,
Well,
I would understand that the insured has to say to the insurance company, we don't want a vehicle on the policy anymore because we sold that vehicle and we got a new one, so please swap out or something like that.
correct. So in this case, the broker that was working for the insured changed the vehicles starting with the third renewal. Right after the third renewal, they took one of the vehicles off. It wasn't the Ford, it was the other vehicle, and replaced it. And then 3 months later, took the Ford off and replaced it again with another vehicle.
Well, is one of your opponent's argument is there's really nothing of record that shows how that happened? And is there a form that one fills out if you're an insurance agency saying, my client, the insured, wants to change the vehicles on the policy?
Well, they renewed the policy again after the Ford was removed, and so in renewing, well, first their premium changed with the change of vehicles, and at one point...
By how much? $25?
No, first it was $120 with the first change of vehicle, and then it went up to went up by a couple of $100 to $1,029 from $768 to $1,029, so a couple $100. And right before the accident, they had renewed the policy without the Ford, with the other two vehicles, and the policy lapsed for non-payment. They came back, they made the payment on the new policy.
So
at
are
the new
you
price.
saying that regardless of your opponent's argument about how the change took place back in July, at some point, the 6-month notice, the premiums were sent that had the two vehicles on, neither of which was the Taurus, so you, the insured, got this in September or so, showing which vehicles were now insured under your policy. You paid the premium insured, and then the missus was involved in an accident of which they're making PIP, and Star
Exactly.
saying, hey, look, you know, it's not a car on the policy, so we decline coverage. Is that what,
Correct.
that's what you're saying?
That's exactly what I'm saying.
Okay.
They knew after the second renewal when they changed and they increased the policy, and then they got, in September, they were supposed to renew in October, so in September, they got a 30-day notice, this is 2013, and it listed the two cars that were on the policy and that would be on the policy if they renewed.
So you're saying the record is, we sent you your policy, we sent you the note, the deck sheet that had the two cars on it. If you, the insured, thought something was wrong or we misunderstood what cars you want on the policy, you needed to let us know. You didn't. In fact, you paid the premium, so we assumed you were happy with the cars that were listed under the policy, neither of which was the Ford Taurus, and off we went. And then Mrs. St. Hilaire was unfortunately in an accident, and now she's claiming coverage when, 3 months earlier when the deck sheet was sent to you, nobody said anything.
That's exactly what we're saying.
Is it? Okay. All right.
Okay, so the court, first, well, the appellee has conceded at this point that you does not include both the spouse and the insured, and but the trial court had made a finding that you included both the insured and the spouse.
So the opposing counsel conceded in the brief that even though they believe this should be affirmed, they concede the status of the law, at least coming out of this district, is that if the policy had been properly changed, if they had made that request, and Star Insurance honored that request, the fact that Mrs. St. Hilaire is not a named owner of the vehicle is not dispositive. She would still not have coverage, right?
Correct.
I mean, their argument is that you guys made these changes without permission, without their consent, and therefore that's why you shouldn't have won, and that's why they did win. But they did concede professionally in their answer brief that, well, the fact that Mrs. St. Hilaire was not an owner, the titled owner of the vehicle, the husband was, that's not controlling, and the trial court's analysis in that regard was erroneous.
Correct.
That's the lay of the land today with
Today,
us, right?
exactly. So I think the main argument on appeal from the appellee's perspective is that Star still didn't meet its burden of proof to show that the insured intentionally changed the vehicle.
Do you agree with the principle that even if we were inclined to reverse the final judgment that was entered in favor of Jacksonville Chiropractic, we're not obligated to remand it with directions that you win? It may still be a factual question based upon the insufficiency of the summary judgment evidence you presented?
Not particularly. I think.
You don't believe that's a principle of law? You just don't want it, you don't want it applied here?
Okay. Well, I don't think that intent is the issue. I think the status.
That's really not my question. I mean,
Okay.
it's not an all or nothing here. If we don't believe that if we conclude based on the record and the argument, et cetera, that summary judgment was improvidently entered in favor of Jacksonville Chiropractic, that doesn't, I'll use Latin, ipso facto, mean that your side should win. That just means they don't win, and it goes back to the trial court and to proceed with additional things. That's a principle. I mean, you want to walk out and say they lost and we won. I get that. They want to walk out and say they won and you lost. We get that. That's why we figure people are here. At least that's what I hear.
Ideally, but if the court determines that there still remains a disputed issue of fact.
That's what they're arguing, is they're saying that that how it was presented below by your side didn't meet the summary judgment standard, so the trial judge was correct not entering summary judgment in favor of Star. But then there's then the leap as to then they won, and they're obviously want to argue that that's a good call here by the trial judge, and you've not demonstrated reversible error. That's
Correct.
well, I assume we're all
So-
here. Am I right?
Yeah,
Did I read that
that's why
somewhere?
I think we're here.
I think so. All right, go ahead.
Okay, but our position is that the only issue that would require evidence at this point from the appellee's perspective position, I believe, is that Stars, or that the insured intentionally changed the policy. And our position is that whether the insured intentionally changed the vehicle on the policy is not an issue. Is not the dispositive factor. It's whether the vehicle was on the policy and whether it was listed on the declarations page as a covered vehicle. In this case, it was not listed, and therefore, so we should have gotten summary judgment. And there's not really any that issue is not part of the analysis for the trial court to find that there was no coverage for the insured. And on that basis, we would ask this court to reverse.
Okay. All right, thank you, counsel. You have a lot of time on rebuttal if you need it. 9:34 specifically.
Morning, may it please the court. My name is Chad Barr, and I have the privilege of representing the appellee in this case. We are asking the court to affirm the final judgment and the order denying Star Casualty's motion for summary judgment. On appeal, Star Casualty has two burdens. One, they have to present an adequate record, and two, they have to demonstrate error.
What's wrong with the record?
In this case, starting with the summary judgment motion. Summary judgment motion was filed in 2020. The only thing that they attached to their summary judgment was an affidavit stating that the 2007 Ford was never insured under the policy, which is obviously a misstatement because it was insured under the policy at one point. And so that's the only piece of evidence that they had. Then we proceed 3 years later, they do nothing. We proceed to a hearing. Plaintiff files a response, we proceed to a hearing. There's no hearing transcript.
What does that matter?
Because in this case, the court has no idea what arguments were presented. In the motion for summary judgment, there's two or three sentences in the motion for summary judgment regarding this precise issue of their affirmative defense of the removal of the vehicle, or the exclusion affirmative defense. So we've got two or three sentences in their motion for summary judgment. We've got an incorrect affidavit.
Well, let me add, I mean, there seems to be a trend, and you do a lot of appellate work. I mean, historically, it's summary judgment, the transcripts of summary judgment hearings are not necessary because you're simply arguing the state of the record at the time, and there's presumption that people are arguing what they argued in their motion. There seems to be a trend in arguments now made by appellees who
Sure.
are happy with summary judgments, say, well, you don't have a transcript, so, Katie barred the door might have gone on, so therefore, it's an applicant type of scenario, which I think that's the proverbial apples to oranges. Applicant is more towards, well, the trial judge heard evidence, made credibility determinations, and we can't know what the trial judge heard because we don't have the testimony or the evidence. We seem to be trending away from that, where I don't know where that is in the actual case law. That
I
supports
agree.
that.
I see it a lot when I'm the appellant.
Yeah, I know. You don't like it when you see the appellant. You're kind of, swinging the hammer this time, and I get it. You got to make your arguments. But I don't.
I think in this,
I understand they have the burden to present a proper record, and if they're, and that was sort of the direction of some of my questions. If you're thin on your motion for summary judgment and your summary judgment evidence, hard to blame the trial judge to say, well, I'm not going to grant it. But the lack of a transcript seems to be the proverbial, since I'm talking apples and oranges, red herrings, I guess I'm throwing
let me
out
say
all
it this
kinds of
way.
fruit and
So
vegetables around here today.
let me say it this way. Ms. Paxton stood here for the majority of her time talking about facts. Notices were sent, premiums were paid, premiums were unpaid. All that is not in the record. It was not in their summary judgment motion. It was not in their summary judgment evidence. And there's no record of what was argued at the summary. I think of all the times that I've seen this argument, this is the one that it really applies to.
Well, there's case law that basically says, you're not required to have a transcript of the summary judgment hearing, but it sure can be helpful at times.
Sure.
Well, and that may well be, but I guess my finer point is, it's not dispositive, It certainly, it becomes, as you're familiar, in Applegate's scenarios, it becomes 99.5% dispositive of any of those cases. You don't have you have no transcript, you have no substitutes, statement of the evidence, and here, of that nature, and but that's different than when it's a legal argument. This is a legal argument about, here's my evidence that I've presented, here's the opposing evidence, judge, as a matter of law, should we win? Isn't that summary judgment?
I think the line to be drawn is, the easiest line to draw with, we're talking about this Applegate argument, is it a legal ruling? So we're typically looking at things like an interpretation of the terms of the policy. We're talking about statutory interpretation, things that don't require the court to see what the trial court considered at the summary judgment hearing.
But at the summary, they're not evaluating the quality of they're saying, here is the evidence that you have presented. What you are showing me, movement, does not rise to a level that I should, as a matter of law, based on undisputed facts, let this case go to a jury, you win. So, that's...
But they're saying you should reverse based on things that are not in the record.
Well, that's again, apples and oranges for some reason are sticking in my head today. Yeah, you're saying, look, your summary judgment motion doesn't present summary judgment evidence that would justify entering a summary judgment, and that's why the trial judge correctly denied your star motion for summary judgment. I get that.
Right.
I agree that's the proper analysis that you should make here, that it's a thin motion for summary judgment, and what else could the trial judge have done? You could have gotten an affidavit from the insurance agency that says, yes, we absolutely sent something to Star because the owner, Mr. St. Hilaire, was I saying that right?
I believe so.
The way, he wanted that changed. So I, as his agent, the agency asked for X for the insured, we asked for that change. Here's a true and correct copy of that was sent, and that's why we, Star, sent the deck action, the notice. That would be summary judgment evidence that you would have a hard time
I agree.
debating about that. You might then get into a scenario about, well, did I really give consent to my agent to say that? But that would be of record. That would be summary judgment record evidence that would seem to be fatal to your client's position.
And the court addressed that in its summary
But
judgment.
that kind of gets back to and I think you professionally conceded that the fact that Mrs. St. Hilaire is not the titled owner of the vehicle is not.
The court made two rulings in the summary judgment. The one we concede was...
One is incorrect, but it's not dispositive.
Correct.
So may I ask a question?
Yes,
I want to
please.
back up just a minute. I fully agree with the notion that fair to include a transcript or a record certainly can prove fatal to certain things, but much to Judge Lambert's fine point, summary judgment, it swings differently. Is a movement entitled to judgment as a matter of law? You've conceded error on the interpretation of the policy language, specifically you and what's required by that, and I think rightly so. Other than whether or not the 2007 Ford was removed from the policy intentionally, I'll come back to that in just a minute, any other factual dispute? Anywhere?
Well,
Any factual dispute present in this case other than your position as to whether or not the Ford was intentionally removed from the policy?
well, I just want to be clear. So we're not arguing that there is a factual dispute. What we're arguing is that they didn't satisfy their summary judgment burden with respect to their affirmative defense, and the trial court did not find an issue of fact. The trial court found that they did not have the evidence to
I appreciate that. Is there a factual dispute between the parties on any matter other than whether the Ford was intentionally removed?
No, and I don't think that is actually a factual dispute. If I stood here and said that's a factual dispute, what I would have to be saying is that we weren't entitled to a final judgment. What we're saying is that based on the evidence,
Yeah?
the lack of evidence, based on the trial court's finding in the summary judgment that they cannot prove their affirmative defense, we moved for final judgment. They didn't respond.
Ford's not, the 2007 Ford's not on the policy.
Correct. And to Judge Lambert's question at the beginning of Ms. Paxton's argument, if it was incorrectly removed, if it was accidentally removed, if it was anything other than removed at Mr. St. Hilaire's request, then it was not a sufficient removal to invoke the exclusion under the policy. That is our position. They have not proven in any way that the removal of the vehicle was sufficient to invoke the exclusion under the insurance policy.
Because there's insufficient basis to determine it was intentionally removed.
There's no basis, not even.
Is that the lone argument you present as to why the summary judgment should be affirmed?
With respect to the final judgment, there's no response, there's no transcript. We don't know what the trial court relied on. I wasn't there. We don't know what the trial court relied on. The trial court, and candidly, they let the hearing proceed. The case was going to trial. The motion was filed based on the summary judgment ruling. The motion was filed. The defense let that motion be heard at a pretrial.
Well, how do they, I mean, if it's your motion, what do you mean they let it be heard? You mean?
Well, they agreed to have the hearing on that motion for entry of final judgment. So it wasn't.
I'm still not following. I mean, they couldn't say, well, we judge, you can't hold a hearing on the plaintiff's motion. What do you mean?
Well, they could have argued, we need more time, we need more discovery, we have things to present, anything that's allowable under 1.510 to say we don't have sufficient evidence, we want to be able to argue in opposition to this. There's not enough time. The hearing was 10 days later, after the motion was filed. They could have said, no, we get the summary judgment time, we get the summary judgment discovery, but they didn't do anything. And remember, we're almost 5 years. By the time this happening, 5 years after they filed their motion for summary judgment, and did nothing. They did no discovery. They did no depositions. We noticed the depositions. We took the depositions. So they did nothing. They didn't file a response. They should have filed a response. They should have filed a response to the motion for a final judgment if they had evidence and if they had argument that we were not entitled to a final judgment. And certainly, they should have had a transcript, because now we're even farther down that Applegate line. Summary judgment, if you have questions about that, I understand. But the final judgment, they didn't file any evidence. They didn't file any response.
Well, the final judgment was entered, it's a summary judgment for your side, wasn't it?
Correct. But that's what I'm saying. The lack of a transcript is compounded by the fact that
isn't, as Judge Soud is pointing out, isn't the record of the 2007 Ford Taurus is not on the policy, and there was a notice sent a few months before that said these are the vehicles that are insured under your policy, of which the Ford Taurus.
Where is that in the record? It's not in the record, and that's so they're arguing facts in their.
Sorry, let me back up just a minute. The exclusion of the Taurus, your contention is not in the record.
There is nothing demonstrating that Mr. St. Hilaire removed the Ford Taurus from the policy.
Is there any dispute the Ford Taurus is not listed on the policy? Those are two different questions in my mind.
Well, it's not on the deck page that was attached to the affidavit. It's not on the deck page.
Okay.
That is true.
Okay.
But that deck page is a renewal, and this court has held, by the way, that a renewal is a continuation of coverage from a prior policy as opposed to a non-renewal policy, which is a change in policies.
Right.
This is a renewal policy, which means what was going on in the prior policy continues on in the new policy. The prior policy is where they're saying that the 2007 was excluded, was removed, and there's no evidence that it was. And so that's what we're saying is the policy should have continued from the prior policy. It was a renewal policy. They concede that. And because it wasn't, there's no evidence that it was removed. And I know that you brought up the intentional. The question is ultimately, was it a removal that was sufficient to invoke the exclusion? And there's no evidence whatsoever that Mr. St. Hilaire intended or wanted or asked for or instructed that.
Why is the question not simply, is the 2007 Ford Taurus listed on the policy? Yes or no? Interpretation of the contract.
That can't be the question, because if they removed it without his permission, or knowledge, then it's not sufficient to invoke the exclusion under the policy. So that is why they included in their affirmative defense intentional. They knew that they had to prove that Mr. St. Hilaire wanted the vehicle removed from the policy. They knew that, and yet they did nothing.
Has there been any claim as far as an errors or omissions policy?
Well,
against the errors or omissions policy?
There's not, but they didn't also raise that as an affirmative
Okay, that's
defense
fair.
either,
That's
nor
fair.
did they bring in that
That's fair.
broker as well. So, Judge, I think I've addressed all the arguments that we've raised in our answer brief. If you have any other questions, I see none. Okay. I'll cede the rest of my time back to the court. Thank you for your time.
Thanks.
Okay, first I'd like to address
Can you move the microphone down?
Sure. Absolutely.
Well, no, you
this-
appropriately put it where you put it. No, she puts it where it puts it, so we can hear you.
Is this
There you
better?
go. Yes, ma'am, thank you.
Okay, first I'd like to address the argument that Starr presented no evidence on summary judgment. If you read, or if you look at Starr's motion for summary judgment, there are at least 7 or 8 exhibits attached, and those exhibits include pages from the various iterations of the declarations page during the coverage period that show which vehicles were covered at each policy change. If you read the plaintiff's response to Starr's motion for summary judgment, the plaintiff states that Starr's agent removed the Ford without when adding the new vehicle to the policy in July. In other words,
Star's agent meaning who? One of
I
your,
guess they were referring to the broker that the
the independent insurance agency.
the independent insurance agency. They referred to it as Starr's agent.
Well, wouldn't that be the insured's agent?
It should be the insurance agency.
Well, I mean,
The presumption is
isn't that what it is? I mean,
it is the insurance agent.
Star, I don't, maybe this is part of Mr. Barr's argument. You know, all State Farm, they have their own agents but I mean, Star Casualty, if I'm getting insurance through Star Casualty, I go through an independent insurance agency who puts me with the coverage, isn't it?
Correct.
So that person that I go see, the neighborhood insurance agent, I don't remember the broker, cover, whatever it was, I go there and they place me with Star, and so if I want to change anything with my policy, I as the insured go to my broker saying, hey, we sold this car, we got a new car, let Star know we want to change coverage. 'Cause we got a
Exactly.
new vehicle.
Exactly. And if the insurance agent was an agent of Star, then they would have had some sort of contractual relationship just with Star. But when the insureds go to the insurance company, to this
So
broker.
you're saying that the
they're-
response to the Star's motion from the Jacksonville Chiropractic was that, well, it's your agent Star that made the change,
Correct.
and that was actually the independent insurance agency that made the change?
Correct.
Or were they referring to an employee of Star, the claims manager?
No, they said Star's agent removed the Ford.
They say Star's agent, XYZ agency, or Star's agent, John Harris.
They didn't name the agent. They just said
Okay,
that Star's
all right.
agent removed the Ford from the policy in July when it added another vehicle. So it seems their position was that the insureds intended to have 3 vehicles on the policy
Well, let me,
starting in July.
one of Mr. Barr's, arguments, certainly appropriate arguments, is that the record is somewhat insufficient for summary judgment to have been granted in Star's favor, and that's why the trial court was correct in denying it. And I know that, we're on a plenary appeal, so any of the orders before that are considered, which is the order denying your motion. But when there's a change like this, is there a document that the independent agency would have sent to Star and saying, okay, my client, Mr. St. Hilaire, would like to change vehicles under the policy for whatever reason?
Well, the declarations page is generated by the application. So when the declarations page doesn't change until there's an application by the insured.
I know, the inference is that we don't change the deck page unless we get something that tells us to change the deck page.
Exactly. That-
On Christmas Day of 2023, I was involved in an accident coming back from Jacksonville. I totaled one of our cars. We got another car a week later. We told Geico, hey, don't insure the car that dummy totaled, me being dummy, totaled. We have a new car, change. Okay, so it gets changed. is there some documentation that shows why Star Casualty changed the deck page?
Both agents that were
Your opponent kind of concedes that if that piece of paper was there, he'd have a tougher climb here, saying, hey, Mr. St. Hilaire told his local agent, John Doe, to contact Star to change that coverage, and that's what John Doe did. And lo and behold, here's this piece of paper in the record. So now what do you say, Jacksonville Cairo? And they would say, oh, tough one. But there's no piece of paper is what he's saying like that.
Correct. There's no piece of paper maybe that shows that they submitted an application to change, but
Wouldn't that have been a good piece of paper to have? At least to button it up for your side? Relative, I mean, that's not a legal term, I don't think, unless some Harris wrote, but.
well, perhaps, but I don't think it's an issue when they renewed the policy, and when they renewed even before they renewed the policy, they received a notice stating what vehicles were on the policy.
So
and then they
are you
renewed.
telling us that, well, yeah, okay, that's a good point after the fact, but we still sent out a new deck sheet a few months before listing what were the current vehicles under the policy, and you guys paid the premium, you the St. Hilaire, so we must have assumed that you were happy with what's on the policy deck page, and those are the two vehicles you want insured, and one of which was not the Ford Taurus.
Exactly. And when the policy was renewed in October, the new price was a little bit over $1,000, where previously it was somewhere in the $800 range. It lapsed in October, and after it lapsed, they came back and they paid
Like
to
the next day or
reinstate the
something like
policy.
that, they paid,
So
right?
again, they were aware of this increased premium, and they had the declarations page that showed the vehicles that were covered, and this all happened before the accident. Star didn't get notice that they wanted to change these vehicles until January 2014. Does that answer your question about
No,
whether they had
I think I'm familiar.
documentation? As far as having a sufficient record, like I said, we don't really, in the court already discussed this with Mr. Barr, but we don't really need a transcript of the summary judgment proceedings to see how the judge ruled and how the court ruled. And
Well, I think part of
issue
the
law.
argument that the appellees now make, and Mr. Barr fairly in light of the trend, is, well, who knows what you all said to the trial judge at the time? You made and believe me, we have these internal discussions here, that you all may have made a 180-degree turn, and the case, the summary judgment hearing may have gone a completely different direction, and because we don't have a hearing transcript, you don't know, judges here on the panel, you don't know what was talked about, and it's the appellant's burden to show, and by not giving us a transcript, maybe Star's casualty attorney said all kinds of things that were adverse to them at the hearing. Now, it doesn't show in the final judgment, but they're saying it doesn't matter, because you don't know. Judge doesn't have to recite everything that was argued at a hearing.
Well, they seem to be claiming that we didn't satisfy our burden to prove this intentional change of vehicle.
Saying you didn't put it, he started off with saying we don't have a sufficient record to show why the trial judge erred because we don't have a transcript, and who knows what may have been discussed, and that's your problem, not his problem. Problem is a broad word, but I mean, that's problematic to your case, is what he's saying on appeal.
But all the rationale for that's exactly how I understood his argument. But
Well, the flip side is, why would I argue anything different than what I argued in my motion?
right.
I assume that
And the order, both the summary judgment order denying Starr's motion and the subsequent order granting final judgment for the plaintiff show the court's rationale, and it's all set forth, and it's sufficient for this court to review and make a understand based on the law whether the court was correct in ruling. Either on the summary judgment issue, the first one for Starr, or the final judgment for the plaintiffs. Whether Starr met its burden would be for the purpose of creating a factual dispute. So if that's the only issue that would be that would be a factual dispute is this issue about whether the insured intentionally changed the vehicle. And they're saying Star didn't meet its burden, but the only reason it would try to meet a burden is to create a factual dispute. In this case, there is no dispute that the vehicle was not listed on the policy when there was an accident. And that's really all the court needs to reverse in this case.
Okey dokey. All right, your time's up. Thank you, counsel, both. Have a safe trip back, and we will stand adjourned.
Okay, thank you.
Have a good day.